Well, welcome everyone. We are live with another episode of Level Up Law. This is a new episode. It's August 23rd, 2022, and you are viewing Attorney Lanier Sims, who is the supervising attorney in our Greenwood office. And we appreciate Lanier being here today to go through the divorce packet of documents that you can use when you are filing for a divorce on your own and having to represent yourself. And welcome, Lanier. So since June of 2020, South Carolina Legal Services has been leveling up your legal knowledge about the areas of law that we practice in. And I do want to note that in 2022, we've included presenters from some of our partner organizations to level up your legal knowledge or just your knowledge in general about how those partner organizations are helping communities across South Carolina. So always stay tuned. It may be that we have lawyers presenting on legal issues, but sometimes we're also giving you really important information about other resources that you can tap into. So today, Attorney Lanier Sims is going to, as I said, review the pro se divorce packet. But before we get to Lanier's presentation, we want you to know and be reminded that this is not legal advice. It's just general information for the public. If you need a lawyer, you can apply for free legal assistance from South Carolina Legal Services. And that information is going to be provided on the final slide that Lanier has today, so you can call or apply online and see if you are eligible for our services. One other quick reminder for our audience, and that is whether you're live today or on the replay, please go ahead and subscribe to our YouTube channel and sign up for notifications so you'll get that alert every time that we upload a new episode of Level Up Law or any other video resource which our attorneys and staff are uploading to that YouTube channel. So Lanier's got a lot to cover, so Lanier, I'm going to turn it over to you.
All righty, thank you, Susie. So I'm going to go ahead and kind of hop into it because, as Susie just mentioned, we have a lot of information to cover today. The pro se divorce clinics are for those individuals who have been separated from their spouse for at least 1 year without cohabitation, have no minor children together, have no property, and have no debts that need to be divided, or you have a signed written agreement as to any child, property, or debt issues between you and your spouse. If you have any of those issues between you and your spouse, we would obviously suggest that you consult with an attorney before proceeding. As Susie also mentioned earlier, by providing these forms and holding these clinics, we are not committing to representing anyone in any way. I included down here our office locations. We are located throughout the state, and most of our offices provide these pro se divorce clinics in person, where they provide you with all the forms, go through all the forms with you in person to allow you time to go through it. And those are generally 2 hours. Today, we're going to try and keep this to about 1 hour and just go through the information, recognizing that you can always pause and go back later, or you can, if you're watching this live, you can go later once it's been posted to YouTube and watch anything you might have missed or that you need a refresher on. I also included information on this first slide for how you can find the forms. I realized that while we're doing this online, some of you may not already have the forms in front of you. The forms generally can be located at the SC Courts website, and I gave some information on how to find those on that website. However, the forms can also be automatically completed by completing an interview on that lawhelp.org/SC website. It essentially takes you through question by question, and you just have to provide answers to the question, and then it will pre-fill in the forms for you to then print out and get filed with the court and get your case started. So with all of that being said, and with those resources available today, I'm also going to try to focus on the process and the steps that you have to take to complete this divorce on your own, and not necessarily going through line by line on each form, because you can find those other resources to help you with that later. So again, as I mentioned, these forms are limited for kind of what we call a simple divorce or a 1-year separation divorce. This kind of outlines in more detail what that includes. And as I mentioned before, while it says, you have no children, no property, or no debts between you and your spouse, this could still apply to a situation where you and your spouse have children or property and debts, so long as the two of you have a signed written agreement between each other as far as how those issues are going to be decided. And as always, if you cannot complete these forms on your own, or your case is in some way more complicated, we would advise that you seek the advice of an attorney for your specific case. A few definitions I want to go over at the start, just so you're aware of what I'm talking about when I say these things throughout this webinar today. A corroborating witness is someone who essentially shows up in court the day of your final hearing to confirm that you and your spouse have been separated for a year. The court's going to require a neutral third party to come in and testify that you and your spouse have been separated for at least a year, just to corroborate what you and your spouse are saying. Default is when someone has failed to properly respond or appear or plead within a time allowed for that purpose. In this case, we'll be talking about it in the concept of whether or not your spouse replies to the divorce proceedings once they're served. The defendant is your spouse or the person who is defending the act against the action. A divorce a vinculo matrimony is essentially the legal phrase for a divorce. It's a complete divorce dissolving your marriage. Marital property and marital debts. These are a little bit more detailed definitions as far as what that includes, but the rule of thumb is essentially anything debt or property-wise that was acquired by you or your spouse during the marriage could be considered marital debt or marital property. In South Carolina, a marriage could be either ceremonial or common law. If for any reason you think you have a common law marriage or you don't have a ceremonial marriage, then this process is not for you. When we speak about a ceremonial marriage, we're talking about a marriage in which you went and got the marriage license from the probate court, went and had a marriage ceremony, and then filed that marriage license with the court once your marriage ceremony was completed. Minor children, again, pretty straightforward definition, but it's going to be anyone under the age of 18 currently, meaning that you and your spouse could have had children during your marriage, but if they're over the age of 18, they're no longer minor children, and therefore not necessarily relevant to your divorce case. The plaintiff would be you. You're the person who is going to be filing this action, the person who is making the complaint. Separation for more than 1 year is the grounds for divorce we're talking about here. Essentially, it means that you and your spouse have lived in different homes and have not had sex or cohabitated with each other for at least 1 year prior to the filing of this case, which means that you have to have lived separate and apart from them and not gotten back together or had sex with them for at least 1 year prior to the date of filing this action. Venue is the county where your case will be heard, or the appropriate county where your case should be heard. And finally, the witness, someone who can provide evidence to the court in your case. This first slide, I've outlined the general instructions for completing a divorce action, and I'm actually going to go back and forth between this slide throughout our presentation today to kind of reference back to it. You'll see that it's set out in general step by step, like 1, 2, 3, 4. These numbers will actually correspond to some of the documents that we're going to be going over later, and I'll explain how they correspond to that. Essentially, all of the documents labeled with the same letter will all need to be filed at the same time, and not letter, number, and the number that they're labeled with corresponds to the step in the divorce process in which they're filed. So you'll see up here where step 1 says to complete forms labeled 1 and has a list of all the forms that are labeled 1 that we'll go through here in a second. All of those, like I said, are going to correspond to the number on these steps. So when you're looking back at it later, that will kind of help you as a reference. The main steps to remember are essentially step 1 is filing. You have to file the case in order to start it. Step 2 is service. Once your case has been filed and kind of initiated, you have to serve it on your spouse in order to be able to move forward. Step 3 is just to wait. Once your spouse has been served, they have a certain amount of time to respond to the complaint. Step 4, once your spouse has either responded or their time to respond has passed, then you can request a hearing. Step 5, after you get that hearing date, you're going to need to actually serve notice of the hearing on your spouse so that they know when the hearing is and that they can appear if they have anything to say. Step 6 is just to prepare for the hearing. You'll notice there aren't any forms labeled for step 6 because in step 6 you're essentially going to be preparing all the forms for step 7, which is the final step of attending the final hearing. Just to go back, as I mentioned earlier, I'm going to refer back to this, so if you didn't have a chance to read all this right now, that's fine. I will go through each individual step and what's required as we go through the forms that are required for that step later on in the slideshow. So getting into the forms that actually need to be completed to initiate your case, you'll see in step 1 here, we have that you need to complete all forms labeled, complete all forms labeled 1, and that includes the family court cover sheet, certificate of exemption, summons, complaint, financial declaration, and motion and affidavit to proceed in forma pauperis. So the first form in that list of documents is the family court cover sheet. You'll see at the the top here where it says county of, you'll need to fill in the county where you are filing the action. And then the next line where it says plaintiff, that will be your name. So you'll need to fill in your name there. This third line down here where it says defendant, you'll need to fill in your spouse's name on that line. Over here on the right side in the top right corner, you'll see there's a small blank. That is for your judicial circuit. If you don't know your judicial circuit, which is unlikely you do, you can ask the clerk of court, or you can just Google South Carolina judicial circuits, and it should pull up a map for you to find which one applies to your county. The docket number right here will be filled in by the clerk of court or by the docketing clerk when your divorce pleadings are actually filed. Just to give you an idea of what it'll look like, it'll start off with the year in which your case was filed. So if it was filed in this year, it would be 2022-DR, which stands for domestic relations. Another dash, and then your county code, which will be specific to your county, and then another dash, and they'll give you 2 or 3 more numbers there, maybe 4 if you're in a larger county, to get your full complete case number right there. Moving down in the submitted by section, you'll need to fill in your information, which would be your name, your address. This needs to be a good mailing address where the clerk can send you any documents related to your case or any notices that they might need to send you. And then an email, telephone number, and any other contact information to give to the court so that they can reach out to you for anything regarding your case. You will not need to fill in the South Carolina bar number section, as that is for attorneys. Moving down, you'll then need to fill in where it says, you'll need to check the box, this second box right here, where it says that this case is exempt from ADR. We will complete the certificate of exemption, explaining what that means here in a second. And then that down at the bottom, or in the middle of the page where it says nature of action codes, you'll need to check the box that says this is for a divorce case. And then you will need to sign and date at the bottom of the page. And then you'll move on to the next document to complete. I did include down here that there is a second page of this cover sheet. There's nothing for you to complete, but you should still remember to include that when you're submitting the pleadings to the court. So the next document we're going to fill out is the certificate of exemption. You see on that last family court cover sheet where we said that this case is exempt from ADR. This is the form that tells the court why the case is exempt from ADR, which essentially means that you're not required to go to mediation or anything else before a final hearing. Again, you're going to fill in the county where you're filing the action at the top, your name and plaintiff, your spouse's name for defendant, the judicial circuit that applies to your county, the docket number. You can start to fill in or you can leave it blank for the docketing clerk to fill it in later. And then you're going to check the top box there that says an agreement has been reached among all parties on every issue. And then you'll need to sign and date at the bottom, print your name, and check the box that says self-represented litigant. So once you've completed that, you'll move on to the summons for divorce. Again, the top portion of these pages is always going to be the same. County where you're filing the action, your name in the plaintiff line, your spouse's name in the defendant line, the judicial circuit, and the docket number. So I'm not going to go over that anymore. I'll just say, fill in the case caption, and that's going to be the same for every page as we move on. So then moving on down to the actual body of the summons for divorce, you're going to fill in your spouse's name on that line at the top that says to the defendant above named. And you'll see that essentially all it says is, you're hereby notified that an action has been filed for divorce in this court. You're required to respond in writing within 30 days, 35 if you're served by mail. And if you don't answer the complaint within that time, then the plaintiff or you may proceed for a divorce against them at that time. You'll then need to sign and then date at the bottom of the page and fill in your mailing address, your information, as this is where your spouse is going to send any answer or other responsive pleading that they might file in response to your complaint for divorce. And then moving on to the actual complaint for divorce. The case caption, again, is going to be the same as all the other case captions. In the actual body of the page, you're going to fill in your name where it says plaintiff blank. Then you're going to fill in in paragraph 1, the first blank, you'll fill in the county where you currently reside, and then the state where you currently reside. And paragraph 2, you'll fill in the county where your spouse currently resides and the state where your spouse currently resides. Paragraph 3, fill in the county that you and your spouse last shared a residence in, as well as the state where you and your spouse last shared a residence. And then for paragraph 4, you only need to check one of these boxes. So if the first one applies, if you have lived in South Carolina for at least 1 year prior to the start of this action, you can go ahead and check that box and move on. If you, for whatever reason, if you haven't lived here for a year, but you and your spouse have both lived here for at least 3 months, you can check that box and move on. Or if you're not a resident of South Carolina, but your spouse is a resident of South Carolina, and you're seeking the divorce here, then you can check the third box that says that you are a resident of another state, but your spouse has lived in South Carolina for at least 1 year. There's nothing for you to fill in paragraph 5. It simply says that you believe this is the appropriate court that has jurisdiction over you and your spouse to hear the divorce. Paragraph 6, you're going to fill in the month and day on the first line. So this is the date of the marriage. The first line is going to be the month and the day. And then you'll fill in the year of the marriage in that second very short line there. And then the county, city, and the state where you and your spouse were married. Paragraph 7 is the date of separation. You'll see here that it says, where it says plaintiff and defendant separated, it says on or about. This means that it does not necessarily have to be the exact date that you and your spouse separated. At minimum, obviously, it just needs to be at least 1 year prior to the date that you're filing this action, which would show again that you've been separated for at least 1 year before. Moving on to page 2 of the complaint for divorce, you'll see actually that paragraph 8 starts on page 1, but it just says that there are, and then it's you check the appropriate box. Either there are no minor children of this marriage and none are expected, or there are a certain number of minor children born of this marriage, and you go ahead and check that box, fill in the number of the minor children and the initials and year of birth if there are any minor children born to the marriage. As I mentioned earlier, this only means minor children currently under the age of 18. So if you and your spouse have children, but they're over the age of 18, you don't have to include their information. This is only children born, during the marriage, currently under the age of 18 when you're pursuing this divorce. For paragraph 9, you'll need to either be able to check the first box that says you and your spouse have no marital property, or the second box that you have agreed as to how the marital property shall be divided. Same thing with paragraph 10 as it regards marital debt. You either need to check that you have no marital debt, or that you have agreed as to how the marital debt shall be divided. Some of the questions that we get when this comes up in our in-person clinics have to do with the definition of marital property and marital debt, because if we say that marital property and marital debt is anything accrued by you and your spouse during the marriage, and you and your spouse are obviously still married, then technically this could mean that everything you and your spouse owns is marital property, so long as it was purchased or acquired during the marriage. So with that being said, what we tell people on this portion with regards to which box should I check, if you and your spouse have no property that needs to be divided, i.e. you and your spouse already have the property that each of you are going to keep, and there's nothing that the court needs to order for one of you to give the other something else, or for one of you to be responsible for a certain debt, then if there's nothing that you need to ask the court to do with regards to any of this property and debt, then you can just check the first box on either of those that says there is no marital property and that there is no marital debt. If you and your spouse, like if you have something in your spouse's that you still need to get back to them, and that's the agreement, and there's something that still needs to be done as to any property and debts, that's when you would need to check the second box, that you and your spouse have agreed as to how the property or debt shall be divided. And then when you appear at your final hearing, you will need to have a signed or a written agreement that has been signed by you and your spouse in order to present that to the judge, and they will attach it to your final divorce decree and make it a part of the order. For paragraph 11, this regards resuming a former or maiden name. Obviously, this is only available for the ladies. For the men, if you're filing this action against your wife and you know what she wants to do, then you can go ahead and fill this section in. If you don't know or are unsure, then you can go ahead and check the third box that says the preference is unknown. For the wives that are filing this action, who know what they want to do, if you want to resume a former or maiden name, then you would check this first box that says the, and then check plaintiff. And then on that line, you would need to fill in the former name that you want to resume. So on all of these pleadings, you would use, whatever your current legal name is. And then when you're filling in this section, you would fill in the name that you want to resume. There's nothing else for y'all to complete on this page, but just to give you an idea of what the rest of it says, paragraph 12 just says that you believe you're entitled to a divorce on the grounds of 1 year separation. 13 is where you give up your right to alimony and ask that your spouse be barred from receiving the same. 14 is that there's no collusion between the parties to get a divorce and reconciliation is not possible. And then the bold portion down here moves into the actual specific request for relief, namely, what do you want the court to do? And so you want the court to grant you an order of divorce on the grounds of 1 year separation. And then you also want the court to grant you an order allowing you to resume a former name, and then fill in what that is, if that applies. If if no name change is requested, you can just leave this portion blank. And then once you've filled that in, you'll need to sign and date this, print your name, and fill in a good mailing address where the court can send you any notices or information regarding your case. And finally, a good telephone number where they can reach you. The next document included to be filed with the initial pleadings is a financial declaration form. I'm not going to go through this line by line because that would take a lot of time. And also, we already have another level of law webinar going into how to complete a financial declaration. So if you guys want, a more elaborate discussion on how to complete the financial declaration and everything that goes into it, you can search on our YouTube channel for that video. Just to give you an idea of what this is and why we are filing it, you'll see I'm going to kind of scroll through it. It's a 5-page form. that includes all of your income, expenses, basically anything financially related to you or your spouse, and gives you a format in which to put all that information down that's very easy for the judge to review and digest. The reasoning as far as why this has to be included, the first easiest answer is that it's required by the court rules. Any party is supposed to file a financial declaration in any case. In family court, it's easiest for you to go ahead and file this at the beginning of the case instead of having to remember to do it before the final hearing. So that's why we tell everyone to do it at the start of the case. Excuse me. And the other reason is if you are asking that the court waive your cost of filing or the cost of service, you're going to have to include this form completed and signed and notarized along with your request for those fees to be waived, so that the judge has an opportunity to review it and get an idea of what your financial situation is before they make a decision as to whether or not to waive fees in your case. So the main takeaways here are you only have to complete the side that applies to you. You'll see there's a husband-father side and there's a wife-mother side. You don't have to guesstimate at your spouse's financial situation. You only need to worry about filling in the information for yourself. The first page is all income information. So the first section is all gross income. The second section down here is all the deductions from that income, like your taxes, your health insurance, any retirement contributions, anything like that. And then at the very bottom, once you have your total gross and you subtract your total deductions, that gives you your net monthly income at the bottom. And then page 2 is all expenses. Some of these definitions, you might not know what it refers to. For instance, maintenance for household. If you're not sure what that means or what any of these might apply to, page 5 of the financial declaration form includes explanations as to what each of those sections mean. So for instance, we talked about maintenance for household. That would be appliance and household repairs, landscaping, things like that. So again, this form is relatively straightforward, but I just want to touch on it briefly. And if you need any more detailed discussion or help getting through it, we have another webinar on how to complete that. So this next form is the form I mentioned earlier that you would submit if you want the cost of filing and the cost of service to be waived in your case. If you don't, want to request that your filing costs or fees be waived, then you can just kind of ignore this section, and we'll get back into other things in a second. But for those of you who will be asking for the cost of filing and service to be waived, this is what you'll need to complete. You'll see again, case caption always going to be the same. You'll only need to fill in your name where it says I blank, being duly sworn, state that I am the plaintiff and I do not have the funds available to pay the cost of filing and service, and I'm requesting that the complaint be filed and service made without cost to me. Once you fill that out, you will need to sign this in front of a notary public or sign it and then have it notarized by a notary. You won't need to fill out anything in this bottom portion. You will simply, complete this form, attach it to all of the other initial documents that you'll need to file with the court, the cover sheet, summons, complaint, certificate of exemption, and financial declaration. And then once the clerk receives all of these, they will give the financial declaration with the motion to the judge for them to review, and then the judge will make a decision to either grant you the right to proceed in form of papyrus, which means that the cost of filing are waived, as is the cost of service by the sheriff's office, or deny leave to proceed in form of papyrus. And if they do deny it, that means that they're going to require you to pay the fees and the cost of service. So at that point, when you initially bring everything to the court, if you're asking for the fees to be waived, you won't have to pay anything at that time. But if your motion to proceed in form of papyrus is denied, then you'll need to pay the filing fees by the date that you're given. So you'll see down here, they will put in a date of which you will need to pay those fees, or your case will be dismissed without further notice, essentially. So going back to the general steps for divorce that we talked about earlier, you'll see everything that we just went through was all for step one. So we just went through all of the forms that will need to be completed in step one, but that's obviously not all you'll have to do in step one. So once you've completed each of these forms, you'll need to make 2 copies of each of them. So essentially you'll have like one original packet with all of the forms completed, and then you'll need to make 2 copies of that packet so that you have 1 original and 2 copies. You'll take the original and the copies to the clerk's office with the $150 filing fee that we talked about, or your motion and affidavit to proceed in form of papyrus if you're requesting that the fees be waived. And then you will have those pleadings filed with the court. If you pay the cost of filing that day, they'll go ahead and file it and probably hand it right back to you. If you're asking that the cost of filing be waived, they'll take it, give it to the judge to make a decision, and then the clerk will get back to you once the judge has decided on the cost, the filing fees and all that. After your pleadings are filed, and once you get the copies of the pleadings back, either that day or later, you have to make sure a copy is served on your spouse. There are a few different ways that can be done. The 2 that I'm going to go over today are essentially acceptance of service, or service by certified mail or commercial delivery service. The other options essentially are serving them, with a sheriff's deputy or a private process server. If you choose to, take that option, then the sheriff's deputy or the process server will have the necessary form to fill out to give you as proof of service once they've done so. And finally, the last option, publication. We're not gonna talk about that today, other than to say, if you attempt to have your spouse accept service, serve them by certified mail, serve them by process server or sheriff's deputy, if you attempt all of these and are unable to get your spouse served, then it's possible that you might have to ultimately serve your spouse by publication. And if it comes to that, you would need to consult with an attorney, because an attorney is going to be required to file all of the special motions and documents and other things in order to actually serve your spouse by publication in the newspaper. Key things to remember here: no matter how they're served, you have to file proof of that service with the court in order to proceed to a final hearing. You could serve your spouse, wait your 30 days, do everything, and show up at a final hearing, and if there's no proof that your spouse was ever served, you're not going to be able to proceed with a final hearing. So you want to make sure that you've done everything appropriately, step by step, and that all of the appropriate forms are filed with the court at each step. So now that we've kind of talked about the options for service, the first one and the easiest one is to have your spouse do what's called an acceptance of service. This form, just needs to be completed by your spouse. Again, you can go ahead and fill in this top portion because you already know all that information. And at this point, now that your pleadings have been filed, you will have the docket number for the case that you can go ahead and fill that in as well. Then you will need to have your, essentially you need to meet with your spouse, have them, give them a copy of the pleadings, have them fill in this form with the date that they were served, the location where they were served. This can be an address, it doesn't have to be. Essentially, it needs to be enough information that when the court looks at it, they can say when and where approximately, or at best, that this person got these pleadings. Obviously, it's best if it's an address. However, if it's like the Greenwood County Library or the McDonald's on Main Street, something that's enough to where the judge can say this is when they got it and this is where they got it. Your spouse then needs to sign and date at the bottom here. You'll see where it says defendant's signature. This cannot be filled in by you. This needs to be filled in by your spouse, who is the defendant in this case. And then they need to print their name, fill in a good mailing address for them, and a good telephone number where they can be reached, because all of this information is going to be used by the court to contact them for anything regarding the case. And so once they have filled this in, you will need to, like I mentioned earlier, file it with the court as your proof of service. If for whatever reason you don't want to meet with your spouse, or your spouse refuses to sign the acceptance of service, the next option of how to have them served is by certified mail or commercial delivery service. And this is the form that you would use for proof of that. So before actually filling in this form, you will need to send the pleadings to your spouse either by certified mail, restricted delivery, return receipt requested, or by commercial delivery service, which is essentially FedEx or UPS. Once you've actually mailed the pleadings out to your spouse and either gotten the return receipt back from the certified mail, or have the tracking information from the commercial delivery service, once you send it to them and have proof that they got it, then you will fill out this form. And so once you've gotten that proof, you'll need to fill in again the case caption, check the appropriate box or line here for how they were served, either by certified mail or commercial delivery service. And then you'll fill in the date that they were served, meaning the date that they received it, and the address block for how it was mailed. So, whatever you put on the envelope that was mailed to them, their name, address, city, state, and zip code in that address block in the middle of the page there. And then you will need to sign this in front of a notary public and attach the return receipt or whatever tracking information you have. And again, file this with the clerk of court as your proof of service that your spouse was served. So you'll see we kind of went over the acceptance of service and the service by certified mail or commercial delivery service. If you choose to, or for whatever reason, have to use a sheriff's deputy or private process server, as I mentioned earlier, you'll just need to contact them and they can give you more information about their process or any fees, and they should have an affidavit of service form that they will complete once they serve the pleadings on your spouse, and then they will either return to you for you to file it with the court, or they'll return it directly to the court. However that's done, you just need to make sure that that proof of service makes it to the clerk of court so that they're aware that your spouse was served and when they were served. And so then you'll see here the next, after, if step 1 is file all of the pleadings with the court and step 2 is to serve your spouse with those pleadings, then the next step, step 3, is just to wait. Your spouse has 30 days to respond to the complaint once they're served with it, 35 days if they're served by certified mail or commercial delivery service, and this is exclusive of the day that they were served, which means that if they were served on, today, August 23rd, the first day is tomorrow, August 24th, and then 30 days from that day, you can proceed with the case if they haven't responded. If your spouse files an answer within those 30 days, either contesting your complaint for divorce or arguing against anything you might have said, like if your spouse says, we do have property that needs to be divided or something along those lines, you should definitely speak with an attorney about your case, because that changes what your case is. It's no longer necessarily uncontested, and you're going to want to make sure that you speak to an attorney to ensure that your rights are protected in that process. If your spouse files an answer before those 30 or 35 days have passed, admitting to or not contesting the allegations, essentially if they file an answer that just says, yes, everything that they said in their complaint is true or admits all of it, then you can go ahead and request a hearing. But if your spouse doesn't file any type of answer within that time, then once those 30 or 35 days have passed, your spouse is in default, which we talked about earlier, which means that their time to respond has passed. And you can then complete an affidavit of default along with a request for a final hearing. So the affidavit of default essentially says that your spouse has been served and that they've had their 30 days and they haven't responded. Again, the case caption is all going to be the same. Down here in the body of the affidavit, you'll need to fill in the day, meaning like the numerical day, like the 18th day of or 17th day of, then the month. So like say the 23rd day of August, and then the year 2022, and as far as the date for when your spouse was served. Then down here, you'll need to check the box for how they were served, either by personal service, through a sheriff's deputy or private process server, by certified mail, restricted delivery, by accepting service, or by commercial delivery service. Whichever way they were served, you just check the appropriate box. And then you'll see down here it says that more than 30 days have passed since the date of service, no answer or other responsive pleadings have been served, that your spouse is in inactive military service or has waived their rights under the Service Members Civil Relief Act, and that they are now in default. And then you will sign this in front of a notary public and file it with the court along with the next document. So the next document is your request for hearing. Again, pretty straightforward. The case caption at the top here. There's a lot of information to fill in here, but it is just your information. So like your name, your address, your telephone number, and your email if you have one, and then all of your spouse's information. So your spouse's name, your spouse's address, your spouse's phone number, and their email if they have one. You'll need to check the box that says the hearing was requested by plaintiff, because you're the plaintiff. Under comments issues, that's generally where we tell people to fill in any dates that you're not available for the final hearing. And then you will need to sign and date this as at the bottom as well. And once you submit it to the clerk, they'll fill in the date of the hearing and the time, as well as the judge that you will be in front of for your final hearing. And you'll see down here, I said, when you take the affidavit of default and the request for hearing that we just completed, when you take those to the clerk of court to actually file them and get your hearing date, you should go ahead and take the next form that we're going to go over, which is your notice of hearing, so that the clerk can go ahead and fill that out for you when they give you your hearing date. The notice of final hearing will need to be mailed to your spouse. So again, the case caption is the same. You can either fill this in once the clerk has given you your hearing date, or you can take it with you and the clerk will fill it in with that information when they set the hearing date. So you'll need to fill in the date, the time, check AM or PM for when the hearing is, fill in the county where the final hearing will be, and then if the clerk is completing it, they will go ahead and fill everything in. If for any reason the clerk doesn't complete it, or you forget to take it when you request your final hearing, just go ahead and scratch out where it says clerk of court, write in your name, sign it, date it, fill in the place where it was filled out, and then write in the address of the family court and the time allotted, which should only be 15 minutes. Once you've filled this form out, or the clerk has filled this form out and given it back to you, you need to mail a copy of this notice of hearing to your spouse via certified mail, return receipt requested. Earlier when we were talking about serving your spouse with the initial pleadings, you had to send it certified mail, return receipt requested, restricted delivery. For this notice of hearing, it just has to be sent certified mail, return receipt requested. Your spouse does not have to be the one to sign for it. They do not even technically have to sign for it. You just need to be able to provide proof that you sent it to them in that way, to show that you've done what's required of you in order to get to a final hearing. And so to prove to the court that you've sent this notice of hearing via certified mail, return receipt requested, you'll need to fill out the affidavit of service by mailing for the notice of hearing. So you'll see this is similar to the affidavit of service by mailing we did earlier, but different because it's just for the notice of hearing. The case caption at the top is going to be the same as it always is. And then you will need to fill in the date that the notice of hearing was mailed. This is not the date received, like if you were serving them the initial pleadings. This is just the date that you actually placed it in the mail. And then the address block for how it was sent, like your spouse's name and their last known address. This one as well, since it's an affidavit, you'll need to sign it in front of a notary public and then file it with the clerk as proof that your spouse was served with the notice of hearing. And so that brings us all the way through steps 1 through 5, where we have filed the pleadings, you've served your spouse with the initial pleadings, your spouse's 30 or 35 days to respond have passed, and they either didn't file an answer or they filed an answer admitting everything, and you've requested a final hearing and gotten the final hearing date. And then step 5, you've mailed the notice of hearing to your spouse, certified mail, return receipt requested, and provided proof of that to the court by your affidavit of service by mailing. And then we're on step 6, which is just to prepare for the hearing by completing all the forms you're going to need for the hearing, going over your sample scripts and testimony that you might have to have at the hearing, and just generally preparing. Just some good things to keep in mind when you're preparing for your hearing. You're going to want to, you're going to have your corroborating witness. So make sure you have someone who is available to attend, who knows that you've been separated for at least 1 year. Make sure you arrive early and that you and your witness are appropriately dressed. If you have any questions as far as what appropriate dress is, you can always contact the court ahead of time. But general rule of thumb is just, like no shorts, no tank tops, no hats, just dress appropriately. Once your case is called, you'll follow the sample scripts for the different testimony that we'll talk about here in a second. And then the judge will decide, whether or not to grant you and your spouse the divorce. And then you can submit the final divorce decree that we're going to go over as well. So step 6 is essentially preparing and completing all of the forms that we're about to go over. So for these, I made them a little larger, and I don't have like the step-by-step run through, just because there's a lot more information on these pages, and so it'll be easier to see with them a little larger. And this is a lot of stuff that we've already gone over in the complaint, so I'm hoping you guys can just kind of fill it in as we go, since it's very similar to stuff we've already done. So again, at the top here, this is the beginning of the form for your final divorce decree. This is essentially the cover sheet for the final divorce decree, which is a judgment in a family court case form. The case caption up here is going to be the same as everything else. Where it says submitted by, that's going to be your name. And then you'll need to check the box that says self-represented litigant over to the right there. Under decision by court, you'll check that first box that says this action came to trial, hearing, or was resolved by consent and an order was rendered. And then down just below that, you'll check that first box that says see attached order, as we're going to fill out the order form in a second here. Moving down to the middle of the page where it says order information, this is going to be a final order. And if final, it will end the case. So you check yes at the end there. Support is not going to be ordered unless it's a situation where you and your spouse have minor children and you have an agreement as to what support is and how it's going to be paid. If for any reason support is going to be paid, then you would check the second box and check how it's going to be paid, either through the court or directly to the CP, which stands for custodial parent, or the person who would be getting support payments. A couple lines down from that where it says this order involves the immediate issuance, dismissal, or does not apply, you're going to check that third box that says does not apply, as there shouldn't be any bench warrants in your divorce case. Then down here where it says judgment, information for the judgment index, you can just basically scratch it out, or if you just want to write in like a NA, does not apply here, that should be enough. And then the judge will sign and date at the bottom here once the hearing has been held. This says, for clerk of court office use only, but if you want to go ahead and help the clerk out, you can go ahead and fill in your name and mailing address over here where it says, attorney for the plaintiffs, and then your spouse's name and mailing address here where it says attorneys for the defendants. You will also, or it would be helpful, some counties require it. It's hard to say statewide how many, but if you want to kind of help speed up the process of getting your final divorce decree back, it would be best if you take with you to your final hearing 2 self-addressed, postage paid envelopes, one for yourself and one for your spouse, for the clerk to mail the final divorce decree to you and your spouse once it's been, filed and everything. And then they will complete this, the clerk of court, excuse me, will complete this as proof that you and your spouse received the final divorce decree. And then moving on to the actual final order of divorce, like I said, I'm not gonna, I don't have the step-by-step blanks listed over here because we're just gonna kind of go through it. And a lot of this is information that was already included in the complaint, or that you won't know until you actually have the hearing. So at the top here, again, the case caption is going to be the same as always. For plaintiff attorney, you can either write in, pro se, which is PRO space SE, which essentially means self-represented in Latin, or you can write in self-represented, or NA, or just your name, whatever you want to indicate that it's just you. You don't necessarily have an attorney representing. Same thing for your spouse, or if they are represented, fill in their attorney's name. There shouldn't be any guardian ad litem involved, so you can just put NA. You'll fill in the hearing date, the judge, and the court reporter, which again, you may not know until the actual day of the hearing. For the first boxes, you need to actually check in the body of the order where it says defendant was or was not present and was or was not represented by an attorney. As I mentioned earlier, you won't really know that until you're actually at the hearing, but just know that you'll need to fill that in with either whether or not they were present and whether or not they had an attorney. Moving down, or sorry, just kind of go through it, you'll see what the order is saying is essentially what is going to happen at the final hearing. So keeping in mind, this is kind of predictive of what we expect to happen at the final hearing. This doesn't mean that it's exactly how it's going to go, but essentially a hearing for divorce was held, defendant was or was not present and was or was not represented by an attorney. This case is before the court upon the plaintiff's complaint for 1 year separation from the defendant, or 1 year separation divorce from the defendant, excuse me. The original family court cover sheet, certificate of exemption, summons, complaint, and financial declaration were filed in the office of the clerk 4. This is going to be the county where you filed this action. And then down here is going to be the date that the action was filed. So it's going to be, sorry, so it's going to be county where it was filed, the date that it was filed, and that should be stamped on your copy of the pleadings that you kept for your records. A copy of these documents was served upon the defendant by, and then you'll just check the appropriate box. Excuse me. You'll see there that there is no box for acceptance of service. In that case, you can just check the personal service box and write in acceptance of service if you want, and then the date on which your spouse was served. And this is kind of saying what's going to happen at the hearing. Essentially, you'll be sworn in, and after you're sworn in, you'll tell the court that reconciliation is not possible. You'll offer testimony, and you'll have a witness offer testimony. And then the body of the order of divorce is going to have a lot, if not line for line, the information that we put into the complaint. So you'll see it starts off with plaintiff, that's you. That's going to be your county and state of residence. And it's going to be your spouse's county and state of residence for the paragraph 2. For paragraph 3, just like in the complaint for divorce, it's going to be the county and state where you and your spouse last resided together. And then paragraph 4 for jurisdiction as we mentioned in the complaint, if you can check the first box, check it and move on. If not, see if either of the other two apply. One of these must apply in order for you to file a divorce in South Carolina. So if for any reason none of these apply, then you might need to figure out what state you need to file your divorce action. For paragraph 5, again, nothing for you to fill in. It just says that this is the appropriate court for you to be in. For paragraph 6, this is the marriage information. So it's going to be the month and day, year that you were married, and then the county, city, and state where you were married. 7 is the separation date, so month and day on this line, and then year. As we mentioned when we were filling out the complaint, this doesn't necessarily have to be the exact day. However, if you're not sure what day it was and you're still kind of guessing, then go ahead and leave this blank. And after the final hearing, the judge will essentially make a decision as to when they find that you and your spouse separated, and they can just write in that date here. Paragraph 8 talks about how your spouse was served. Essentially, it says that they were served with a copy of the pleadings. And just like on the first page, you'll need to check how. If they accepted service, you can check the personal service box and then fill in the date that they were served. 9 and 10 go together in the sense that they are always going to be opposite. So, we talked about earlier how, we determine if your spouse is or is not in default, and essentially the answer is whether or not they filed an answer within the appropriate time. So if they did file an answer or other responsive pleading, then they are not in default. And if they did not file an answer, then they are in default or is in default. So no matter how you check these, it's always going to be diagonal, essentially, because they're always going to be opposite. For 11, there's nothing for you to fill in. It just says that all legal requirements have been met. If for whatever reason any of the requirements as to filing, service, notice, and waiting periods have not been met, then the court is not going to allow you to receive your final divorce that day, and there may be something you have to fix before you can come back for another final hearing. For paragraph 12, this will fill in your witness's name, and essentially it says that you and your witness were present at the hearing, that you both testified about you and your spouse living separate and apart for more than 1 year. And then paragraph 13, based on that testimony, the court finds that you have lived separate from your spouse for at least 1 year. 14 is the child custody, visitation, and support stuff, which is, again, the same as in the complaint, in that you either check the first box that there are no minor children, or check the second box, fill in the number of children, and then fill in their initials and year of birth. I think I mentioned that earlier, but I didn't explain why. You don't want to fill in their full name and their full date of birth because these are technically public records. And so just to be safe, we only include the initials and the year of birth. If for any reason the judge wants more information than that, that can be relayed to them at the final hearing without having to put it on the forms that are going to be in the public record. And then finishing up the child and custody and visitation stuff in paragraph 14, either custody and visitation are not contested, or you and your spouse have reached a written agreement which is attached. And that's why, again, we say that it needs to be a signed written agreement so that the court can attach it to the order and incorporate it and make it a part of this order, meaning that it's then enforceable just like any other portion of the order. 15 and 16, marital property and debts, just as we discussed earlier. If there's nothing really, if you and your spouse technically may have marital property and debts, but you've already divided them and you're not asking the court to divide them, then the first boxes should be checked, but if there is something that still needs to be divided between the two of you, then you need to have that signed written agreement that can be incorporated into the order, and then the judge will check the second box. 17 and 18 just say that you and your spouse are waiving alimony and that reconciliation is not possible. 19 relates to the name change. So if you, the plaintiff or wife, or just so you'll check whichever box, either for you or your spouse, plaintiff or defendant, whoever requested that their name be changed. And then again, plaintiff or defendant, whoever it is that's getting the name change, and then fill in the current legal name on that first line, and then the second line will be the name that it is being changed to. So that would be the former or maiden name in the second line. And finally, paragraph 20, that there's been no collusion between you or your spouse in this action. And finally, in 21, that you're entitled to a divorce from the defendant on 1-year separation grounds. Then we get into the actual body of the order, where, sorry, if you just excuse me one second. So then we get into the actual bold portion where you're requesting what you want, which is the divorce. The judge will check that any agreements between you and your spouse are in your best interest and in the best interest of any minor children. And if applicable, those agreements are made a part of this order, that everybody's barred from receiving alimony. And finally, if anyone requested the name change, that it's granted and what the actual name change would be. The judge will then sign, date, fill in, when they signed and dated this. And you will also need to, hand up to them what's called a DHEC report of divorce form. I'm not going to go into this one line by line either, because it's, again, fairly self-explanatory. Main takeaways: you need all of your information in the first 6 boxes, then all of your spouse's information in boxes 7 through 12. The marriage information will be in boxes 13 through 17, and you should have all of this information. By the time you go to the final hearing, you'll have the place of marriage, the date of marriage. The type of decree is going to be an absolute divorce. The county of decree is going to be the county where you filed, and then the docket number is your case number. You won't need to fill out anything in boxes 18 and 19, as that will be completed by the clerk, but you will need to make sure you filled in boxes 20 through 25 with your and your spouse's information, and then you won't need to fill in 26 or 27 because you won't have an attorney, but down in 28 where it says legal grounds, you'll need to fill in or write in 1 year's continuous separation. So you'll see at that point, we're almost done. And just kind of go back, like I said, that is all going to be filled out kind of ahead of time, but to give you an idea of how the actual final hearing is going to go, the judge will call you and your spouse in there, swear you in, hear your testimony, and then once the judge essentially issues their decision, you will hand them the final decree of divorce and the DHEC form for them to complete. So just some final thoughts and helpful tips to remember. Show up on time. You always want to be on time. What you don't want is to have to have this hearing continued and then wait another month or however long before you can get another court date. Do not show up under the influence of anything. The judge may actually ask you and your spouse during the course of the hearing if either of you are under the influence of anything Just to confirm, they don't do this to offend. It's just something that they need to make sure of anytime they're hearing testimony from anyone or issuing a decision based on that testimony. As we mentioned earlier, kind of make sure that you dress appropriately. I've given a little bit more information of what this might be like, and I say at least dress like you're going to church, but really that means like slacks and a button down for guys, maybe a dress for women, but doesn't necessarily have to be, just something presentable to where the court isn't going to be distracted by your appearance, essentially. And then the last things I wanted to go over are the sample script for your testimony and the witness testimony. Again, these are very straightforward. The way that it'll work in the actual hearing will depend on the judge. Some judges may be more willing to help you and your spouse get through this process by asking the questions themselves and just swearing the two of you in and going through these questions. However, some judges might not provide you any assistance and may just say, proceed with your case. If that happens, then you'll be sworn in. You will need to just kind of talk through or read through your testimony line by line, saying your name, address, where you live, where your spouse lives, all of the information essentially that you included in your complaint for divorce, because that's the facts that the judge needs to know in order to grant you your divorce. So you'll just need to kind of read through this document essentially, and then you'll see at the bottom here, listen carefully to any questions you're asked and answer truthfully. While these are all of the questions that give the information required for the judge to make a decision, there may be something else that the judge thinks they need to know in order to make their final decision. And if that's the case, they'll ask you, what any questions they might have. Just be sure to answer them. And also, finally, if at any time the judge tells you you can't proceed, or they say, like your spouse wasn't served or your spouse wasn't given notice, or there's something wrong with your case where you won't be able to have a final hearing that day, that's when you just need to say, I would respectfully move for a continuance of the hearing, and the judge will hopefully, continue the final hearing until a later date, which would give you time to remedy, whatever issue that might be, whether it's your spouse never got served at all, or your spouse never got served with a notice of hearing, or whatever you might need to do to get to where you can have a final hearing. You just need to ask for a continuance so that you can do that. And then this is the kind of sample script for your witness testimony. Essentially, the witness just needs to establish that they know you, they know your spouse, and they know that the two of you have been separated for at least 1 year without cohabitation. And not only that, but they would have known if you and your spouse had gotten back together during that time. So that is a very quick, slightly abbreviated run through of all of the pro se divorce forms. Like I mentioned earlier, we do have office locations all over the state. So if you want a copy of these forms, you can contact your local office and they may be able to provide them to you, or you can go to the SC Courts website, go to court forms, quick links, under quick links, and then search for the appropriate form. Or if you do the interview on lawhelp.org/SC under our self-help form section there, it'll just ask you a bunch of questions and you provide your responses, and it'll actually fill the forms in for you and then give you a PDF document that you can print out with all those forms in it. And finally, if you have any other questions, or if you need to apply to our office for services in this or any other matter, you can contact our intake service at that 1-888-346-5592, and that intake is office is open Monday through Thursday, 9 to 6. And I will hand it back over to Susie to provide you guys with any updates on our upcoming Level Up Law webinars at this time.
Well, thank you so much, Lanier. That was a terrific presentation. And hey, you did it in an hour and a half. And like you said at the beginning, usually those clinics where we help walk through people through these divorce packets is a good 2 hours. So nice job on that. Appreciate it. Really just, you can represent yourself on these 1-year separations without cohabitation with the help from some good resources like we have here at South Carolina Legal Services, and a nice hand-holding walkthrough by our great attorney Lanier Sims from our Greenwood office. So thanks so much. And also thanks to you, our audience, for tuning in, and also for supporting the Level Up Law show. We do know that from a lot of comments that we get, that the information we provide is helpful to you, the members of the public who really need the legal information. So I think presentations, especially ones like this, are the kind of thing that we really want to get out there, because that's the main purpose of Level Up Law. So keep those comments coming, and let us know if there are other topics maybe that you'd like to see us, and we'll certainly try to do that. So thanks again, Lanier, for a great presentation. And I want to thank our producer in the background, Kenneth Elliott, who is always back there. You may not realize it, but he is making sure we don't have any technical glitches along the way, and he does a great job for us with that. So I'm Susan Ingalls from Law. That concludes today's webinar. Thanks, everybody.